Welcome back to another episode of Litigious, the number one podcast for common sense discussion of legal topics in the news. I'm Scott Peterson. Giovanna is here with me, as she always is. A few interesting cases to talk about today. Before we do that, just a reminder, if you enjoy the show, like, subscribe, and share with your friends. If you have any questions, reach out to us at Litigious Podcast on Instagram. And this podcast, just a reminder, is brought to you by Charayu Peterson, a plaintiff's serious and catastrophic injury and employment discrimination law firm. So if you have questions about any of that, reach out to us at our website, DerazioPeterson.com, or at Derazio Peterson on Instagram. So this JPMorgan case, which we've talked about the last couple of episodes, has taken another turn into the interesting. So for just a quick recap, this case arises out of two employees of JPMorgan, one of whom filed a complaint alleging that his supervisor of sorts, a woman, basically kept him as a quote unquote sex slave, made all kinds of uh, off the wall comments about him needing to have sexual relationship with her in order to get promoted and stay within his job. She denied it. She subsequently filed a defamation lawsuit against him. He initially tried to file the complaint, or did file the complaint anonymously as John Doe. That was his name was outed very early on by the New York Post, among others, I think. And recently, this past week, he lost a couple of important things. Number one, a court in New York held that he cannot remain anonymous in his lawsuit any longer. For the record, his name is Charayu Rana. Uh, so the court indicated that he could not remain anonymous any longer. And that came on the heels of news that he and his attorney had parted ways, which probably not great. And so that's where we are. The court indicated that keeping the identity secret would be prejudicial, and that there's really no authority to keep his name anonymous, particularly in this case where the cat was essentially out of the bag. And they had a oral argument on this. The Post didn't do his departing attorney any favors, referring to him as resigned and unprepared, which is kind of a tough way to refer to the attorney. But what do you think about this? We talked about the fact that his allegations were pretty explosive, and that generally, as an attorney who represents plaintiffs, you try to vet your clients and their claims as much as possible before putting them into a complaint. The fact that his attorney is stepping away from this case does not necessarily indicate that he no longer believes his client, but it also is not a great sign.
Well, I don't think he has another lawyer, so I think that makes it a little bit more difficult to sort of spin it as, from the client's perspective of, oh, we just went, our separate ways, or I have this new lawyer or whatever. Like I interpret it probably that, they had some kind of either falling out or his lawyer kind of dumped him. I mean, typically you can't dump your client when you're in litigation. You have to ask if the client doesn't have another attorney and they're not, either dumping you or switching lawyers. So usually you'd have to make as the lawyer a motion to the court to withdraw. That I don't know that that was made public. What I saw was more of like a consent to change attorney, but he, as far as I know, doesn't actually have another attorney and he's continuing pro se, at least at this point, which I think is very dicey in an employment case. Like those are pretty specialized, and I don't think most people are probably capable of representing themselves in a case like that, especially against a big bank that probably has big lawyers who, know how to litigate these kinds of cases. Um, but yeah, I'm not really surprised because, like, even though we've been saying we kind of give a legitimate plaintiff's law firm the benefit of the doubt, in terms of, not taking a terrible lawsuit, this has definitely very publicly sort of blown up into something where I think, for the most part, at least the public opinion seems to be on the side of this guy might have made this whole thing up.
Yeah, it's pretty crazy. I think to your point, I mean, the case is in state court, which is a little bit easier to navigate than federal court. You are allowed to appear without an attorney. Courts don't typically like it. Coincidentally, there was just an article in the New York Times today about how AI has led to this like massive increase in people filing lawsuits pro se, which means without an attorney. And whereas they used to just send in like handwritten complaints, now they're sending in these like long drafted complaints that have been, written through Claude or ChatGPT. And it doesn't necessarily change the merits of the claim. It just means that they are better written. And to your other point, just because you can write a complaint doesn't mean that you're able to navigate the complexities of litigation, including discovery, depositions, trial. So in this situation, operating without an attorney is probably dicey. My guess is if JPMorgan did in fact offer this guy $1 million before the lawsuit commenced, he's probably wishing he had taken it.
Yeah, and I mean, I think also kind of reading between the lines a little bit, once those sort of numbers were coming out, I would also think that that would potentially put you in a adverse situation with your attorney of what your reasonable expectations are. I mean, $1 million is not an unreasonable settlement in any, real employment case because your damages are tied to most primarily are tied to your out-of-pocket loss. Now, in a really egregious sexual harassment case, do you have, emotional distress and things like that too? But, $1 million is not nothing in a case like this. And he turned it down asking for 20 million. And that is incredibly unlikely to ever receive because there's like statutory, caps on how much compensatory damages you can get in certain types of cases. Um, that's just an exorbitant number. Like if you're making, $10 million a year, maybe that wouldn't be outrageous, but I don't think that that's what was happening here. And the guy left to go to another job that I don't think he was able to hold down. So that's like a whole other, interruption of what your damages are. You're not going to blame, an employer for your lost wages for the rest of your life if you were able to go and get another job and then you didn't hold that one down either. So that's to me like an unreasonable expectation of the value of a case like that. So I could see, your attorney-client relationship sort of falling apart. Just even from things like that, putting aside whether your lawyer suddenly feels like you may have not been truthful.
Yeah, and really, attorney-client relationships do fall apart in occasionally over the amount of damages that the client believes they're entitled to, and sometimes the attorney may not agree with that based upon, the actual proof. So yeah, that very well could have been the case. With respect to the confidentiality, it's not surprising. There's, the sort of default is that lawsuits are public, and it's very hard for a regular plaintiff in a lawsuit to be anonymous. So I'm not surprised that the ruling went that way. And, according to the article, at least the judge asked his attorney for case law or precedent supporting the argument that there should be confidentiality. And he said, I'm not aware of one or not aware of any or something along those lines, which is never, you never want to be in court trying to make an argument and not having any authority to back it up. That's
Yeah,
not
and
a
there
good,
honestly there probably isn't much precedent out there for
yeah.
that because we had talked about this the first time this came up. I had said that it's really not common to do that. Usually it's with minors, usually it's like with maybe people who have like developmental disabilities or something like that. But like a regular plain old employment, sexual harassment case, I've never seen one of those where somebody has proceeded as, a John Doe. And the standard is pretty high. Like if this is in New York County, like, I've had a case in New York County that we sealed. We won the motion to seal, but the parties' names were still under their own names. And it's not easy to, seal a case. They have to make like a pretty specific ruling that you have good cause for that because all the case law is in favor of, the courts being public. So yeah, I'm not surprised. This seems to be falling apart. Um, it's pretty interesting case.
Yeah. Yeah. I suspect our next reporting on it will be, well, I don't know. I don't want to make a prediction on this one just yet. the next reporting could be that the case was dropped, but you never know. And now the problem is they said the cat's out of the bag, but the allegations have been made, so I don't see this woman dropping her defamation claim anytime soon, especially if she smells blood in the water that this might not be true. Like that, that he might be getting ditched by the people who are supporting him. So
Yeah, and I mean, we had said that typically, you don't necessarily have a successful defamation claim based on claims that were made in litigation. But I do
yeah,
think from some of the reporting I've seen now, it does look like maybe he's gone beyond the legal pleadings in talking about this because apparently he hired like a crisis PR firm. I mean, this is one of those things where like you have brought this down upon yourself.
yeah,
Um,
100%.
but yeah, so I think he has been doing, some public statements about this. So then you kind of start to get, beyond the lawsuit privilege. But yeah, I mean, I wouldn't be surprised if I don't think I would be surprised if he dropped it. It's the craziest thing ever. I mean, if he made it up, it is like that is like so crazy. Like I can't even, like, I don't even understand how that happened.
Yeah, I totally agree. All right, we'll report back on that once we get more. Another case was reported involving a settlement arising out of the Charlie Kirk shooting. We'll talk about these as they come through, just because I think some of them are interesting. This one is a woman fired by Ball State University in Indiana, which is apparently a state school. Um, she she worked as the director of health promotion and advocacy at their campus in Muncie, Indiana, and was fired in September after she made a private Facebook post, referring to the killing as a tragedy, but saying that it was a reflection of the violence, fear, and hatred that he sowed. And then she went on to say, "If you think Charlie Kirk was a wonderful person, we can't be friends." So that prompted, according to the school and the school's president, that post resulted in a flood of outraged phone calls and emails to the university, some warning that they would withhold donations, and at least one parent saying they plan to withdraw their child from the school. Apparently, some callers threatened violence. So the president said, quote, "The reaction was extraordinarily damaging to our university's reputation and image, and it was exceptionally disruptive to our mission and people." So she was fired and then filed a lawsuit claiming that her constitutional rights were violated because she was speaking as a private citizen on a matter of public concern. The ACLU took her case up, and she settled it for $225,000, which the school referred to as a modest monetary payment in order to, that was basically less than it would have cost to defend the lawsuit. So, interesting. The amount of the settlement does suggest that, it's not a huge settlement, but it is a reflection that they probably violated her First Amendment rights by firing her. That said, a similar situation came up at our our law school where we went to law school, Albany Law School, where there was a lot of backlash after a professor made some Facebook posts. Now that's a private school, so it's a different situation, and the professor wasn't fired, but this happened. I mean, this happened everywhere, and I'm sure, we're going to see more of these cases.
Yeah, I think that this is just another example, same that we said last week, of kind of a cautionary tale that I think a lot of these schools and employers just sort of capitulated to like a frenzy that happened. Right after he was killed. And I think it was short-sighted, and they probably are not applying their standards evenly amongst people, which kind of gives you like an equal protection claim as well. If you're, in a public employer, you could make that type of argument too. If you're applying it differently based on, people's race or something like that, then you have, Title VII types of claims. And then for public employers, you may have these First Amendment issues also. So I think it's very dicey to have fired people for this. I mean, there's certainly situations where someone has made, a Facebook post or social media post that's so beyond the bounds of, decency or is violent or is threatening, where you can understand that it would be, disrupting the school or something like that. But this was a very divisive person who I think wanted to be divisive and wanted to and use that as part of their business. And to say that people were should lose their jobs because they expressed some sort of disagreement, that's a little bit different than celebrating, somebody's death. And I think people made, that the idea that you were sort of celebrating someone's death so broad and encompassing that people were not even permitted to express some sort of disagreement with this person's views, which was what his entire, brand was. Tell me why I'm wrong. Tell me,
Yeah.
why you disagree with me or whatever. And was, sort of a self described sort of champion of free speech. So I find this all very ironic in many ways. And at the same time, a cautionary tale. And I'm not going to be surprised to see this. I have a feeling there are going to be a lot of people who get settlements for losing their jobs because of this.
Yeah, I think the, there's a line between calling for violence and saying something that's condemnable but also not illegal. And I think that the outrage does sort of miss the point of what he was trying to say, which is you should be able to express yourself even if people don't agree with you. But again, private sector versus public sector makes a huge difference. I did misspeak earlier when I was talking about our law school. That was related to comments about the October 7th attacks, not the Kirk assassination. So, in any event, yeah, we'll talk about these cases as they come in to the extent that they're interesting. Just good reminder, you gotta be careful. All right, moving on. There is a lawsuit against Lyft that is getting ready to go to trial, and it's interesting for a couple of reasons. It's a very sad case. The plaintiff, Kristen Jangara, says she was sexually assaulted by a Lyft driver in 2019 after she was out celebrating with friends. She said she called the driver. The next thing she knew, what was supposed to be a 6-minute ride turned into 51 minutes of, quote, terror, which included waking up with the driver on top of her. It's horrible. He was charged with kidnapping and rape. Um, this made news initially, and we haven't talked about it because in the court filing, she filed her complaint, and in response, Lyft filed what is known as an answer, which is a response to a complaint. And among other things, in the answer, they asserted that she knew the risks of injury and damage involved in her conduct, and that she failed to act as a reasonable and prudent person would with regard to her own safety. That prompted a huge uh, media outrage. She had a quote that said, "I think it's unbelievable that they claim something like that." Um, from our perspective, those claims are fairly standard in lawsuits in response. So we file a lawsuit, and in the answer, the defendant asserts a number of what are known as affirmative defenses. And they're usually boilerplate language saying things like, you knew the risks of your activity, this was your fault, your damages aren't what they say, you haven't made a claim. And so, from that perspective, the headline's a little bit misleading because they may be taking that position in the trial. I doubt it. But we wanted to kind of talk through that. And what else is interesting about this? She's refusing to settle, right?
Yeah, so when that all sort of blew up, that was kind of years ago. This case has been going on for a long time. Yeah, she has declined to settle from what I understand, and they're going to move forward with a trial. I think she wants this to be, a public kind of reckoning, and which I think is happening against these rideshare apps because there are a lot, and we've talked about this before, a lot of reports of sexual assault. I think in this particular case, this person potentially would have had I believe that this person would have had something come up in a criminal background check that she's alleging they did not perform.
Yep.
So yeah, I mean, these have to be held accountable in some way because you're in a very vulnerable position. We talked about like now there's reverse racist or reverse gender discrimination cases against Uber for their woman only choice that you can make. But these things they're trying to add some of these protections for a reason because this has been a big problem. But yeah, I mean, going back to like what you were first mentioned, we're not quite consistent on it, but we used to have like a little piece of our podcast that we called misleading headline. And I do think that that was something a little bit, misleading, that if you're an attorney, you kind of know that these are just boilerplate defenses. That being said, theoretically, a human being, an attorney, should be proofreading your answer. And I would say in a situation like this, even if you feel like in service to your client, you have to include some sort of boilerplate, like this is your fault defense, it probably could have been softened. The way that one was written in this particular case, I think was inviting, a problem.
Yeah, look,
And by the way, like you knew the risk that if you got into my car, somebody might rape you. Okay, I mean that's not. I don't know what kind of.
yeah,
That's
I mean, it's
probably
like,
not a very good argument to make. I mean, sometimes they'll just say like, your damages are caused by your own culpable conduct. Fine, just leave it at that.
yeah, I mean, like I said, I think a lot of times these are just boilerplate and people don't give much thought to them. I get answers in all the time where, it will assert something as a defense that I've already addressed with the attorney or is like clearly not the case. And, it's like you just want to, it's a waste of time to even deal with it. But
Yeah, I mean, for
yeah,
the
it
most
doesn't look
part,
good
you
either.
ignore these things, but I could see in a high profile case, whether it's like a litigation tactic or what, for like a plaintiff's lawyer or for the client themselves to like, expose this in the press and be sort of outraged about it. But I do think like that's, we don't tend to necessarily do that kind of thing. So I think we probably would have just like ignored it and said, or you asked them to withdraw it,
Yeah,
which I think
that's
they
what they,
actually did, which they did do.
yeah. No, that's the misleading headline piece. All right. Well, if that case goes to trial, we will talk about it because that's an important case. It's important to hold these companies responsible. They do, we use Uber and we use Lyft, but they do a lot of work to really limit their liability. And Uber in particular does a lot of lobbying to get laws changed to reduce their culpability towards people who are hurt in their cars. And it's important that people keep holding them responsible because if they had their way, they would have no responsibility whatsoever. And if you found yourself either, injured or assaulted in one of these cars, if it's up to them, they're not paying you a penny. So, these cases are actually really important right now. So, all right. Last but not least, Clavicular, who we talked about last week, who has popularized the maxing movement, which, according to articles, intensely augments one's physical appearance to include or to increase attractiveness. He's accused in a lawsuit in Florida that was filed last month of serving an excessive amount of alcohol to a minor and having non-consensual sex with her at his parents' house on Cape Cod. This came to your attention because we go to we go to Cape Cod most summers, often to Chatham, and that is apparently where their house is. So he was apparently a bouncer at a local establishment that we've been to a bunch of times.
Yeah, I mean, this has two components to it. One is the disturbing allegations against him of
Yeah.
over serving a minor, which has a million problems in and of itself, even putting aside whether there was an assault. But and then the assault itself. So you can use the civil justice system to hold someone accountable for an alleged sexual assault. I think the girl had tried, I think the reason why this is in Florida is because I believe, is alleged to have sort of invited her from Florida, that's where she lives, to his parents' house at the Cape to do something having to do with this looks maxing, like she was going to be some sort of woman looks maxer.
Yep.
And then, obviously she's alleging that this took a turn for the sinister. So I guess we'll see, we'll kind of keep an eye on that case and see how that develops. But yeah, from like the pop culture perspective of it, this was like one of the few times where I delivered a piece of information to our 16-year-old son, and he actually like thought it was interesting information that this guy has a house in Chatham and was a allegedly bouncer or security person at the Squire, which is like the beloved pub in the middle of town. I have
Yeah, I
I
mean the
I have
allegations.
not seen this person there. I don't know.
I mean,
I don't
if
know that I would recognize him if I did.
no, and if these allegations are true, this is a bad guy. I mean, they talk about he's putting injections into, into this woman's cheeks. I don't know.
Well, this whole
This whole thing is
yeah,
weird.
I mean the whole movement is dangerous. I mean, I will say that this optimizing your physical attractiveness is something that women have been beaten over the head with since like the beginning of time. But for young men and like being the parent of like a young man, I find this is all disturbing as well. Like, I mean, this is giving people like complexes about their appearance. It's like creating some sort of like Lord of the Flies situation. These people are literally physically injuring themselves. They're like injecting themselves with who knows what. And it's pretty like, I mean, I think that a lot of people in this day and age sort of like take the position of, oh, I'm just, I'm just talking, I'm just doing this, I'm just asking questions, I'm just doing this, I'm just doing that. But like these health related things cause genuine harm to people. So I have like a objection to this whole movement. You want to be attractive? Fine. Like everybody, I mean, this is not like anything new. Now social media has to turn it into this like horrible, thing. You're on mute.
Oh, amateur hour over here. Um, I'm sure I had to mute. There was a leaf blower outside my office. I'm sure if he is in fact guilty, hopefully he gets what's coming to him. So, more to come on that. Anything else before we wrap today? We have a tight window.
No, I don't think so.
All right. Well, thanks again for listening. We will be back again soon with another episode discussing legal stories in the news. If there's anything you want to hear about, please feel free to reach out to us. As always, like, share, subscribe, and we will be back again soon.